All right, you ready to proceed, Mr. Scott?
Yes, Your Honor.
All right, we'll go on the record in State of Kansas versus Stephen L. Coder, case number 21 CR 54. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
Charged up for Stephen Coder, and he's present as well, Your Honor.
All right, and Mr. Ketley, are you appearing as his ISO?
I am, Your Honor.
All right,
Judge, we also have Miss Clary here, who was a courtesy supervisor too.
all right, Miss Clary, if you could turn on your video, please. All right, good morning. You're
Morning.
Sarah Clary. You're with the 4th Judicial District Community
Correct.
Corrections. All right. We're scheduled today for a hearing on a motion to revoke probation. Announcements, Mr. Scott.
Your Honor, he's gonna admit with explanation some of these allegations. I mean, he admits he was arrested, which is allegation number 1 and allegation number 2. He admits that he did not get the treatment started in time or to get the so he has to get a new assessment done because he didn't get that finished up in time, and he admits that he failed to pay the court costs, restitution, and attorney's fees as ordered.
All right, and he's admitting that he was arrested? Is he admitting that he failed to notify his ISO of his arrests?
Stephen, is that correct? You failed to notify your ISO?
No, I let them know as soon as I got out of jail and what was going on.
Okay, it sounds like he's claiming he did notify them, Your Honor.
All right, is he waiving his evidentiary hearing?
If they're going with the allegation 1, allegation number, well, with that caveat, Your Honor, I guess that if they're dropping the part where it says he failed to notify his ISO, he is.
All right, Ms. Gillette, your position on what's been stipulated to?
I think he might have notified his ISO, the second one, not the first one. I think that's the issue here. He didn't notify them of the first one. He might have the second one, but he still hasn't done his treatment nor paid anything on his case.
Can we just remove that part of the allegation, Jill?
The what part?
About notification.
It doesn't say he didn't notify on the second one, just the first one, because he didn't notify.
Okay.
I just need to know if he says he notified the ISO of his arrest on the first one or not, and if we need to take evidence on that issue.
Yeah, Stephen, did you hear that? Are we contesting notification of the first one?
Cause I let them know about everything. I'm pretty sure I even wrote it on the back of the form you fill out every time you go see the probation officer.
Okay.
All right, Ms. Gillette, which officer would attest to this one? Is that Mr. Ketley or Ms. Clary?
Believe it was Mr. Catley who filed the first one. Yes, it was Mr. Catley that filed the first one.
It would be, I believe it'd be under ISO Clary, because he was one who was supervising him at the time.
All right, do you wish to have testimony on that issue, Ms. Gillette?
We can. I'll call Miss Clary.
Ms. Clary, could you please raise your right hand? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead, Ms. Gillette.
Miss Clary, did he notify you of his arrest on June 26, 2025 within 24 hours?
I do not believe I was notified within 24 hours. No, I would have to look through all of the report forms. If he says that he wrote it on the back, I would be willing to look through all those, but it would take a little bit of time.
And did he report to you on the day after he was arrested, or was it on a regular schedule?
It would have been on a scheduled date.
So he didn't make an extra special appointment to come tell you that he was arrested?
No.
I'll pass this witness to the defense.
All right, Mr. Scott,
Ms. Clary, so you're saying that he may have wrote it on the back of one of the forms? Is that what you're saying?
Correct. It just likely would not have been within 24 hours.
Okay, but you'd have to go back and look through those to be able to tell when it was done. And
Correct.
if it was done. Okay. No
Yeah.
further questions, Your Honor.
all right, anything else, Ms. Gillette?
No, he's admitted to the rest of it.
All right, thank you, Ms. Clary. All right, Mr. Coder, you are waiving your right to evidentiary hearing regarding the allegations that you failed to obtain a new substance abuse evaluation and engage in treatment.
Not that I was aware of. Talking to my lawyer, thought he was going to ask for a continuance so I can get this case that I have at 1:30 taken care of.
Stephen, that's not what he's asking you. He's asking you if you admit that you failed to get the substance abuse evaluation completed.
I got it completed. I just didn't get to do the treatment in time before I had to get another evaluation.
All right, is he admitting that he needs to obtain a new assessment because of that?
Yes, I am. That I do have to obtain a new assessment.
Okay. And are you admitting that you failed to pay your costs, restitution, and attorney's fees as ordered?
Yes,
And you haven't made any payments?
I haven't been able to know.
All right, and you understand on those remaining two allegations, you have a right to have a hearing if you're contesting those allegations?
Yes,
And you're waiving your right to have further evidence presented regarding those two allegations?
I have no idea right now. I'd have to talk to my lawyer. I do not know what that means.
All right, you were present when there was testimony presented by Miss Clary regarding the issue of whether you notified her of your arrest?
Yeah.
Or Miss Gillette asked her questions?
Yeah,
And then,
I-
then your attorney was able to ask her questions. You were present during that, correct?
Yes, sir.
All right. You have a right, if you're contesting or if you don't agree with the other two allegations, you have a right to have evidence taken regarding those two issues in the same manner that it was taken on the first allegation. Does that make sense?
Yes.
Okay. And you're, rather than the court hearing testimony again from either Mr. Ketley or Miss Clary, you're agreeing that you violated your probation by not paying and not getting your treatment done. Is that what you're admitting to?
Yes.
All right. So you're basically, when you waive your right to the hearing, you're saying it's not necessary for the court to hear evidence because I'm admitting to it. Is that?
Now, yeah, I get it now. Yeah.
Okay. Do you need to visit with Mr. Scott about any of those concepts before moving forward?
That I'm not sure about. I would have to refer to him if he's. No, I don't know. Yes,
Okay.
Mr. Scott.
Well,
I think I pretty much
I
understand
just
it.
want to make sure you understand what you're doing and what's going on, Mr. Coder.
Yeah, that's what I'm trying to do too, just to make sure here.
Do you need to visit with Mr. Scott any further?
I don't believe so, no.
Okay. All right, well, I do find that these to be substantial violations. I'm not violating on the fail to notify. I'm not convinced. think that he probably did. Whether it was within 24 hours is undetermined, but not getting the treatment done after all this time is a violation, and not making any payments as directed is a violation. I think those are substantial violations. So I am going to find that you violated your probation, Mr. Coder. We're ready to proceed to disposition.
We are, Your Honor.
All right. What are the state's recommendations?
Your Honor, my recommendations are that Mr. Coder serve as underlying. We've already sanctioned him once, told him he needed to get in and get his drug and alcohol evaluations done, needed to get into treatment. One of the main reasons that he is here is to do his probation and treatment. And it was a condition originally. He has not done his treatment, and that's the main crux of being on probation. This was a border box case. It was a special rule case. He was on felony post-release when this crime was committed. He has, in a border box case, a requirement to do the treatment program that was recommended to him. It had to be available, and he had to engage in that program. It was part of his special conditions that were even delineated by the court, and he failed to do that thing. If you're not amenable to treatment and you're not completing your treatment under the border box standards, we've already sanctioned him once. It's time for him to go serve his sentence.
All right. Thank you, Ms. Gillette. Mr. Scott, your recommendations?
Yes, Your Honor, it is a drug case and marijuana case. I'd ask that the court consider staying application of imposing the sentence to give him one final chance to get into treatment. That, you know, we could set this over. He's got his other pending case. We could set this over for 60 days. And if at the end of that 60-day period of time, he hasn't completed his sentence and completed his evaluation and begun treatment, then the court could go ahead and impose the underlying sentence. But I think in best interest of society, Your Honor, is in a case like this is rehabilitation. And I know that we've had some difficulty getting that accomplished, but I think with the sentence hanging over his head and a 60-day stay of that, with one final opportunity to get the evaluation done and get the treatment started, then if we come back in 60 days and that's not been accomplished, then it's all on Mr. Coder. He's given one final chance to get this accomplished, Your Honor. And I think that hopefully that would work. And I think it's worth the effort and in the interest of society that we do that.
Has he completed any treatment?
Yes, sir. The first time I got put on probation for the case originally, I got the evaluation, did the treatment, but they considered it completed, just unsuccessfully completed. So when I got violated, they made me get another evaluation, and that is this evaluation that I didn't get completed all the way.
All right.
His first time that he was up, Your Honor, he continued to give multiple urine samples positive for marijuana up until his most recent one before that was January 14th, 2025. He continually gave positive UAs.
Mr. Scott, what's the pending case you referred to?
He has two of them, Your Honor. One of them, I think, is going to be dismissed, the misdemeanor one, but it hasn't yet. Then he has a felony marijuana possession that is pending in Woodson County.
His Wilson County case is scheduled for today at 1:30, but they do allow Zoom hearings in Wilson County, so we can Zoom him from our jail.
Your Honor, the Wilson County case, that's allegation number 1. That's where that came from.
All right. Mr. Ketley, any anything you have to say regarding Mr. Coder's, either you or Miss Clary?
Other than I'm not trying to speak for ISO Clary, however, I mean, he did complete an evaluation after his last arrest on that. I believe they even paid for his assessment. He completed it in July, but didn't even start treatment. So now that assessment is null and void because it's over 60 days old.
Okay, is he been reporting to Miss Clary most of the time or part-time and some to you?
He's been reporting to ISO Clary.
All right, Miss Clary, what would you say regarding Mr. Coder's performance on probation?
He has reported as scheduled the majority of the time. Typically, if he can't report, it's a transportation issue. I think the biggest issue with compliance was just his failure to complete the treatment, especially after having new charges. It seemed pretty important that he would do so.
All right, and do you take any position on any recommendations that have been made?
I don't know that I would recommend prison. He hasn't committed any violent offenses. He has been reporting, but also I don't know that he's amenable to probation if he's unwilling to complete the treatment recommendations.
All right, thank you, Miss Clary. Mr. Coder, anything you would like to say at this time?
All I can really say is the 60 days, if I don't have it done, Your Honor, I will gladly go in without a fight. I'm just asking for the chance to get it taken care of. I had so much stuff to do in a matter of time, and I know it was pretty much my fault getting in trouble again. But in anything, and if you give me the 60 days to get the evaluation and treatment done, that's all I can really ask for is that. I mean, I've got 4 kids, and I'm the only one working now. It's about the time of year where everything's having to start to get done, and I'm actually starting to be able to work.
Well, weren't you given that chance back in May when you were here for the same types of violations?
Yes, sir, I was. It happened so fast. Like I said, it was in May, and then in July, I got everything I needed to get done in those 2 months, and then I just got in trouble again. I messed up, and like I said, all I can really do is ask for you to give me the 60 days, like my lawyer asked, so I can show you I'm not messing around.
Well, I'm gonna give you 60 days, but I'm gonna give you 60 days in jail as a sanction here. In lieu of an outright revocation and just sending you to prison, I'm gonna order you to do 60 days in jail, then I'm gonna place you back on probation.
Is this going to be able to be done like in sanctions on weekends so I can still work, or
No,
how is this going to be done?
you're gonna be taken into custody now by a sheriff's deputy, and they'll take you upstairs to start serving your 60 days.
So there's no way I can't check in tomorrow so I can tell my wife and get everything situated and settled. I mean, I could be here whatever time you need me tomorrow. I mean,
No, you've
chance
had
to-
you've had plenty of time leading up to today. There was the possibility that you were going to go to jail or to prison today. You had plenty of time to make any accommodations that you needed to in the event.
I didn't
that would
even get a chance to talk to my lawyer until today, Your Honor. I had no idea any of this was coming. I tried contacting him. He seemed to have been busy and couldn't get back to me. Like, that's all I'm really asking is for another 10 hours to let everybody know. I mean, I'm missing Halloween, my son's state game for football. I'm missing it all. Like, as of right now, having to go in, I can't do anything. I will
Mr.
be here. You
Coder,
gave me a chance to check in last time.
There's
I mean,
consequences to.
I understand.
Your probation.
willing to do the
and that's
time.
the consequence. So I'm not.
So
You should.
I'm
have
not even
thought
able
about
to
that.
let my
had a
wife
first-
know I
Mr.
gotta.
Coder, listen to me. You had a first appearance on October 14th where you were advised as to what the allegations were. So you had notice as to what was going on.
Your Honor, I had no idea. You just explained to me everything today, what everything meant, what they were talking about and what was going on.
Judge, this is, Mr. Cutter, this is your first.
I really,
All right, Ms. Gillette, I'll address the defendant, and I'm done.
I really,
with it. Mr.
really all I'm
Coder,
asking,
Mr.
Hey,
sir.
Stephen, you're gonna have to be quiet and let the judge talk. I think he's hearing you. You don't have to talk over him. Your Honor, on
Sorry.
his behalf, I
Sorry,
would
I'm
just,
sorry.
Stephen, you gotta quit talking. On his behalf, Your Honor, I would ask that the court give him 12 hours to just notify everyone and report back. I don't think he's a flight risk. I'm confident he'll do that. And it just gives him an opportunity. I don't think he fully expected what was going to happen, Your Honor. He did, and he is correct. He did call me, and I briefly chatted with him. I told him I had to call him back, and then I didn't get him called back.
All right, I'm gonna waive additional appointed attorney's fees. The request to check in at a later date is denied. I'm gonna order that he be taken into custody to serve 60 days. Does he need to be extended?
Your Honor, I believe he's not set to expire until May of 26. So if he is able to get his stuff done, we can let him go then.
And who does he need to report to once he's released?
ISO Clary again.
All right, Mr. Coder, you'll need to report to Miss Clary once you're released from custody.
Yes, sir. What I was really wanting is my wife and 2 kids are out in the car. I didn't want them to have to be.
Hey, what's
sitting
your
out there
phone
for
number? What's your
hours.
phone number? And I'll call him.
Thank you. So, could you just let her know I am going to jail right now so she can go ahead and go home, and I will call her when I get situated.
Okay.
Thank you. That's all I needed. I'm ready to go, Your Honor.
Anything else?
Let's do this.
All right, we'll be in recess.
Thank you, Your Honor.